If you think you're safe because you have a concealed carry permit, this new ruling just changed where you can legally carry it. And I am not speaking in hypotheticals. 4 days ago, on June 25, 2026, the United States Supreme Court issued a 6-3 decision in Woolford v. Lopez that directly strikes down laws affecting concealed carry permit holders in 5 of the most restrictive gun states in America. Hawaii, California, Maryland, New York, and New Jersey all had what gun rights advocates called the vampire rule. That rule is now unconstitutional. The Supreme Court said so. And if you live in one of those states, or if you travel there, you need to understand exactly what changed and exactly what has not changed. Subscribe right now because this decision is 4 days old, and most of the analysis you are seeing online is either incomplete or wrong. Let me start with what the vampire rule actually was, because the nickname is colorful, but the legal principle behind it is important. Under normal American common law, the rule for entering private property that is open to the public, meaning stores, restaurants, gas stations, doctors' offices, shopping centers, any business that invites the general public in, has always been that you have an implied license to enter. That implied license comes simply from the fact that the business is open. You do not need to ask permission to walk into a grocery store. You just walk in. The owner can revoke that implied license by posting a no trespassing sign or asking you to leave. But the default is that you can enter. This is the common law rule that has existed in America for centuries. After the Supreme Court's 2022 Bruin decision confirmed the right to carry firearms in public for self-defense, several states that had previously made public carry nearly impossible needed a new strategy. Hawaii was one of them. In 2023, Hawaii passed a new law that flipped the common law default specifically for armed carry. Under Hawaii's law, a concealed carry permit holder could not carry a firearm onto private property open to the public unless the property owner gave express and affirmative permission. The default was reversed. Instead of silence meaning you can enter, silence meant you cannot enter armed. You needed the property owner to opt in by specifically saying yes before you could bring your firearm. Hence the vampire rule. A vampire cannot cross the threshold of a home without being invited in. Under Hawaii's law, an armed permit holder could not cross the threshold of a business without an invitation either. The penalty for violating this rule was a misdemeanor punishable by up to 1 year in prison. Think about what that meant in practice. A concealed carry permit holder in Hawaii who stopped at a gas station to fill up his tank without having previously obtained the gas station owner's written permission to be armed on the premises was committing a crime. A permit holder who walked into a pharmacy to pick up a prescription without the pharmacy owner's express consent was committing a crime. A permit holder who sat down at a diner without getting the restaurant's written permission was committing a crime. As Justice Alito put it in the majority opinion, the Hawaii law imposed severe restrictions on the daily activities of residents who had satisfied the state's rigorous requirements for the issuance of a carry permit. It did not ban public carry directly. Instead, it made it effectively impossible to carry anywhere in public without creating an administrative nightmare of obtaining permissions from every business you might enter on a given day. The Maui residents who challenged this law, Jason Wolford and others along with the Hawaii Firearms Coalition, argued that this was exactly the kind of evasion of the Bruin ruling that the Constitution does not allow. Hawaii could not ban public carry outright after Bruin, so instead it made public carry so practically difficult that it amounted to the same thing. The federal district court agreed with the challengers. The Ninth Circuit reversed and upheld Hawaii's law. The Supreme Court granted certiorari and heard oral argument on January 20, 2026, and on June 25, 2026, the Supreme Court reversed the Ninth Circuit 6-3. Justice Samuel Alito wrote the majority opinion, joined by Chief Justice Roberts and Justices Thomas, Gorsuch, Kavanaugh, and Barrett. Justice Barrett also wrote a concurring opinion, joined by Justices Thomas and Gorsuch in part, specifically addressing the argument that this case is really about property law and not gun rights. Justice Kagan wrote a separate dissent. Justice Jackson wrote a dissent joined by Justice Sotomayor. Hey, 73% of people watching right now are not subscribed. This decision came down 4 days ago. The full analysis is still developing. Subscribe right now so you get every update as it happens, because the practical consequences of this ruling are going to be felt across 5 states in the coming weeks. Let me walk you through Alito's majority opinion because the reasoning matters. The core holding is simple and stated in the first paragraph of the opinion's operative analysis. A state may not prohibit licensed concealed carry permit holders from carrying handguns on private property open to the public unless the property owner gives express permission. The court began its analysis with the text of the Second Amendment. The right to keep and bear arms includes the right to bear arms outside the home. Bruin established that in 2022. The question in Wolford was whether Hawaii's default rule burdened that right. Alito's answer was yes. The law directly restricts where permit holders can carry. Any law that does that implicates the Second Amendment and must be justified by historical tradition under Bruin. Then the court asked whether Hawaii had a valid historical analog. This is where the opinion gets particularly interesting. Hawaii offered several historical laws that it claimed supported its default prohibition rule. The court rejected all of them. First, Hawaii pointed to colonial and founding-era laws that prohibited carrying guns onto private property without the owner's permission. The court found these laws were about hunting on farmland and other agricultural property. They were directed at poachers wandering onto land where game could be found, not at citizens carrying firearms into urban and suburban businesses as part of their daily routine. The laws targeted unauthorized hunting. They had little to do with the Second Amendment's core objective of protecting the right to self-defense. They were not relevantly similar to a law prohibiting all armed entry into any business open to the public. Second, Hawaii cited a Louisiana statute from the 19th century that restricted carry on private property. The court rejected this one with particular force. Alito noted that the Louisiana law was from the Black Code era, a body of laws enacted specifically to suppress the rights of formerly enslaved Black Americans after the Civil War. Against this history, the court wrote, Hawaii's claim that this tainted artifact from Louisiana's Black Code illuminates the original understanding of the right to keep and bear arms cannot be taken seriously, and even setting aside its origins, the statute was neither widespread nor widely accepted, disqualifying it as evidence of a genuine historical tradition. With no valid historical analog, Hawaii's law failed the Bruin test. It was struck down. The line from the opinion that has already become the most quoted of this decision is Justice Alito's rejection of Hawaii's broader cultural argument. Hawaii had essentially argued that its restrictive approach to guns reflected the unique values and traditions of its people, what the state called the spirit of aloha. Alito's response was direct. The Second Amendment has the same meaning in all parts of the United States. It cannot give way to the spirit of aloha in Hawaii. This sentence is simultaneously a legal ruling and a statement about the nature of constitutional rights. Rights enshrined in the Constitution apply equally in every state. A state cannot claim cultural distinctiveness as a basis for diminishing constitutional protections that apply everywhere. Now let me address the dissents because they articulate serious arguments that will be made again in future cases, and you need to understand them. Justice Jackson, joined by Justice Sotomayor, argued that the majority is asking the wrong question entirely. Jackson's position is that this case is about property law, not gun rights. Property owners have the right to exclude people from their property. The state can set the legal default for how that exclusion works. Hawaii simply set the default differently from the common law rule. It said that the default is no carry unless the owner says yes, rather than yes carry unless the owner says no. In Jackson's view, there is no constitutional right to enter someone else's private property at all, let alone with a firearm. The Second Amendment therefore is not even implicated. Jackson concluded her dissent with a pointed accusation. Today's decision makes one thing clear. The court's objective is protecting guns, not consistently preserving any principle of law. Justice Kagan wrote separately to argue that even if the Second Amendment applies, Hawaii's historical analogies are sufficient. She read the colonial-era hunting laws more broadly than the majority and found them relevantly similar to Hawaii's rule. Justice Barrett's concurring opinion directly responded to Jackson. Barrett wrote that Jackson's argument misunderstands the role of historical evidence in a Second Amendment challenge. The fact that a property owner has the right to exclude does not determine whether the Second Amendment is implicated when the state creates a default rule about armed carry on those properties. The question is whether the state's default rule burdens Second Amendment protected conduct. It does, and Hawaii cannot justify it. Now let me tell you the national impact in specific practical terms. Hawaii's law is struck down immediately. California, Maryland, New York, and New Jersey had enacted nearly identical default prohibition rules for their own post-Bruin carry regimes. All four of those laws are now constitutionally vulnerable under Woolford's holding. Maryland's was particularly exposed because its appeal was already pending, waiting specifically for the Woolford decision before proceeding. The Second Circuit, Third Circuit, Fourth Circuit, and Ninth Circuit had all been striking down or blocking these default rules in various cases. Woolford sets a single national rule that resolves the issue definitively. As one legal analysis put it, this leaves very little room for a state to run this play again. What does this mean practically for concealed carry permit holders in those 5 states right now? In Hawaii, you no longer need the property owner's express permission to carry into a store, restaurant, or other private business open to the public. You can carry under your permit as you would in most other states. The owner can still tell you to leave or post a no firearm sign. If they do, respect it. But you are no longer committing a crime just by entering. In California, Maryland, New York, and New Jersey, the legal status is transitioning. The laws are now constitutionally vulnerable and will be challenged and blocked in the courts in the coming weeks and months. Before you rely on Woolford to change your carry behavior in those states, verify the current legal status because the old laws may still technically be on the books until courts formally enjoin them. Do not assume that a Supreme Court ruling that a law is unconstitutional automatically means it has been removed from the books in your state. Formal legal proceedings are required. Consult an attorney about the current enforceable law in your specific state. There is one critical thing the ruling does not change, and I need to be very clear about this because some coverage has been misleading. Private property owners retain full authority to exclude firearms from their property. If a business posts a no firearms sign, you must respect it. If a business owner tells you that firearms are not permitted, you must comply. What Woolford changed is the default. In these 5 states, the new default is that you can carry in businesses open to the public unless the owner specifically opts out. The old default was that you could not carry unless the owner specifically opted in. The owner's authority has not changed. The power to set the background rule has shifted from the state to the common law. Also, Woolford does not affect sensitive places. Schools, government buildings, polling places, courthouses, the places where the court has already said the government can restrict carry, remain unchanged, and Hawaii's other gun restrictions, bans on carrying in bars, at beaches, in parks, are not affected by this ruling. The case was limited to the single question of the default rule for private property open to the public. Let me also connect Woolford to the broader trajectory of Second Amendment law in 2026, because this case does not exist in isolation. The same week Woolford was decided, the Supreme Court issued the 9-0 ruling in Hamanai, limiting when the government can prosecute drug users for possessing firearms. The same term produced the 8-1 decision in Rahimi in 2024, upholding domestic violence restraining order disarmament. The pattern is consistent. The court is using the Bruin historical tradition framework to protect gun rights against laws that lack solid historical support, while allowing restrictions that do have adequate historical grounding. Under that framework, Hawaii's vampire rule failed. The Virginia assault weapons ban, the Illinois pica ban, and the challenges pending before the Supreme Court to magazine restrictions and so-called assault weapons bans are all being tested against the same standard. Woolford is not an isolated ruling. It is one more data point in a consistent direction. Your practical action steps. If you are a concealed carry permit holder in Hawaii, understand what has changed and what has not. Carry is now legally permitted in private businesses open to the public, but watch for posted signs, and know that the sensitive places restrictions Hawaii enacted remain in effect. If you are in California, Maryland, New York, or New Jersey, monitor the legal developments closely. The vampire rule in your state is constitutionally dead after Woolford, but enforcement and compliance take time to work through the courts. Get current legal advice about your specific state before changing your carry habits. For everyone, understand that the Second Amendment is being interpreted broadly and consistently by the current court. Post-Bruin, the government bears the burden of justifying restrictions with historical tradition. Laws that evade rather than comply with that framework are being struck down, and the Supreme Court is watching closely. Subscribe right now because the remaining decisions from this court term, the expected ruling on birthright citizenship in Trump versus Barbara, and any orders on the assault weapons ban cases are going to follow in the next days to weeks. I will cover them all. Do not get your analysis from a viral headline. Get it here. And as always, this is educational content only, not legal advice. For your specific carry rights in your specific state right now, consult a qualified firearms attorney who knows the current status of the law.